Are you thinking of filing a breach of contract lawsuit? There's 4 things you need to prove, and let's take a look at them in this video. So before we go down this road, a lot of people will come to my office and say, I want to file a breach of contract lawsuit. So-and-so breached the contract, we had a whole deal and something fell apart. And before we go too far down that road, we want to look through what the elements of a breach of contract are and make sure they actually have the proof, they have the claim, they have the right facts to be able to show that there was in fact a breach of contract. 4 elements you need to know. Number 1, there had to be a valid contract. Number 2, you had to perform your obligations under that contract. Number 3, the other party didn't perform under the contract. And number 4, and it's very important, you were damaged as a result. It sounds like it's really simple, but let's look at each of the steps to make sure you understand what you need to prove and what's important for that breach of contract lawsuit you're considering. Number 1, was there even a contract? It seems almost too simple, but even though you think you have a contract, we have to make sure there actually was a contract. Now, if there wasn't a contract, that doesn't mean you can't bring a lawsuit based upon your dispute with somebody else. We have things like equitable remedies. We have things like unjust enrichment, account stated. We have other ways to prove that the other party is holding money or holding something that belongs to you and should be returned. But if there's no contract, you don't want to bring a claim for a breach of contract because it's easily dismissible by the court. So we want to make sure we understand what is needed to make sure we have that contract. When we look at a contract, we need what we call offer and acceptance, meaning we have offered something to the other party and they've accepted it. There are terms to the contract that everybody agrees upon. Consideration is the next step in the contract, and this is a legal term for something of value being exchanged. So I'm buying 100 widgets from you for $100. So you're getting the $100, I'm getting the 100 widgets. We have consideration under this contract. We also have to make sure that everybody is capable of signing the contract. This is really important these days because a lot of times what I'm running into is online influencers are trying to sign contracts, but they're not of age. If you're under the age of 18, you can't legally sign a contract. If you're high on drugs, if you're under impairment, you can't legally sign a contract. So we need to make sure that both parties are able to actually sign that contract. And in the business context, is the person signing the contract on behalf of the other business actually empowered to make that contract? So we need to make sure everybody is legally capable of signing the contract. And finally, the contract itself has to be legal. So with all due respect, you can't file a contract or enter into a contract with your local drug dealer. You can't enter into a valid contract to buy illegal firearms from overseas and ship them around the world as a gun dealer. These kinds of things are not legal contracts. So we need that clear offer and acceptance. We need consideration. Everyone has to be capable of signing, and the contract itself has to be legal. Now, if your name is not on the contract, if you're not the one who's entitled to be enforcing the contract, the court may actually not let you file a breach of contract either. You need to make sure you are a party to this contract. Step 2 in our process, did you perform what you needed to perform under the contract? Now, the last few years have taught us that sometimes you're not able to actually perform. There could be a pandemic interference, supply chain issues, an act of God. We call these things force majeure, meaning it's a force outside of your control that makes it impossible for you to perform the terms of the contract. If that's the case, the first place we look under the contract is for a clause that literally says force majeure. If that clause is in there, that's the first place we look in a breach of contract case to see whether or not that act of God, whether that pandemic or that supply chain interruption actually excuses performance, or whether we have a different issue we're going to have to deal with. Step 3, did the other side fail to perform? So if the other side didn't hold up their end of the bargain, then that's your claim. That's going to be the key of your case, is that you've performed, but they haven't. So if they haven't performed what they had to do under the contract, that's really going to be the key source of your breach of contract claim. And then number 4, were you actually harmed? So if there's been no harm, then chances are you're going to have no damages. So you can bring a lawsuit. You can win that lawsuit on liability, meaning the other party is liable for breaching the contract. But if there's no damages, you've spent all that money on an attorney and you may not be entitled to any money. So for example, let's say you ordered silver ball bearings and you got gray instead, but it doesn't matter because they're inside the engine and nobody will ever see the difference between silver and gray. Let's consider, have you really been damaged? Because you know what? The ball bearings work. They fit. Everything is fine. It's just the color is a little bit off. So maybe you don't actually have damages. That's not going to be a material breach that would allow you to get significant harm and get significant compensation from a court for what we call a breach of contract. Now, this is the part of a breach of contract that's especially important for you to make sure you understand, and that is, what are your damages? If your damages are going to be $500, then you want to consider whether it makes sense to actually hire an attorney. However, if your damages are millions of dollars, then we want to make sure that we are getting that breach of contract properly pled, because there is a lot of money at stake. Now, a lot of people will ask me next, what about my attorney fees? Can I get them paid if I have to bring a breach of contract action? And like many other things we've been talking about in this video, the first step we have to do is look at the contract itself. If the contract says you are entitled to attorney's fees if you have to bring a claim for a breach of contract, then you'll find a lot more attorneys will be interested in representing you. I recently had a case where somebody was being sued by a daycare for, I think, a $500 or $600 deposit. It didn't seem to make any sense. The person called my office, says, I don't understand why I'm getting sued by the daycare. And then we looked at the contract and we realized that the reason they're being sued is that the daycare would get attorney's fees. So although they're only owed $500 or $600, their attorney would get paid if they had to bring a breach of contract lawsuit. In that case, we were able to work with the other attorney and work out an agreement so that nobody had to bring a lawsuit. But when you see those kind of situations where you say, why is somebody being sued over $200 or $300, and especially if it's in federal court for some reason, it's usually going to be the attorney's fees or some kind of statutory damages that say, if you've breached the specific type of contract, you automatically get your attorney's fees or some kind of special damages that really will rack up the bill for the damage department. If you're involved with a business contract and you own a business, you need to remember that you cannot represent your business in court. So if you're a small business, if you're a single member LLC and your LLC is sued, you can't just show up in court and say, I'm here to represent the company. An LLC requires an attorney to represent the company, and generally companies have this requirement in court. There's very few exceptions, one of them being if you were actually an attorney yourself and you're admitted in that court where you're being sued, you could appear on behalf of your company. But generally, when we're dealing with the general public and normal companies, if you're a single member LLC or you and a couple of friends own a business and you're being sued, you can't just show up in court and try to represent the business before that court. So the bottom line here is you need to have more than just a gripe with the other party of the contract. We need to make sure we have the right facts, we have the proper pleadings, and we have the legal backup so you can win your breach of contract claim. Now, there's a lot of other little issues that will come up in a breach of contract claim. And if you haven't seen it already, you can actually go on Amazon. You pick up the book I've written, How Contracts Become Lawsuits. If you pay attention in the comments below, I'll actually give you a link where you can get a PDF copy of it for free, so you don't have to even pay for it from Amazon. If you have further questions, you'd like to set up a call with my office about a breach of contract case, you can go over to my website, andrewmayers.com. On the front page, there's a red legal strategy session button. Click that and you'll be taken to my scheduling page. We can set up a 15 or 20-minute phone call to go over the facts of your situation and see whether or not it seems like a good idea to get you some next steps for a breach of contract case. Before you go too far down that road, I would suggest you either read the book I suggested or let's have this phone call, because we want to make sure we've got your case on a solid legal foundation before we bring that breach of contract action.